Aloha, everybody. This is Marcus Landsberg. How are you doing? I got two things I want to talk about today. For those of you who are paying attention, today is, November 5th, 2021, and we're watching the trial where are we at? In Glynn County, Georgia, of the three men who killed Ahmaud Arbery. And we've been talking about this with a lot of people about what's going on, but there are two things. There's a lot of things to talk about in the trial, but there's two things in particular I'd really like to talk about that are relatively out of the ordinary from other cases we've seen. These are not the only things out of the ordinary, but these are things I want to talk about. So those two things that I really want to talk about are, number one, there was an objection made based on Sixth Amendment grounds, which is relatively rare. And number two, one of the defense attorneys of the three reserved opening. Now, first, let me say, I understand that this is not the trial of Ahmaud Arbery. This is the trial in Glynn County, Georgia, but I don't want to keep saying the three other names. And we understand what I'm talking about when I say this. Number one, let's talk about the Sixth Amendment. Sixth Amendment is the right to confront your accuser, the right to have an attorney in your defense, and it's also the right you have to see what's going on in the courtroom. It turns out one of the defendants was unable, it sounds like, because of the positioning of the things in the court, to be able to see some of the jurors or potentially the witness. So it's relatively rare that this comes up, but when you have very complicated cases with multiple defendants, and especially when you have lots of audiovisual equipment in the room, both for talking to the jury as well as talking to the world at large, sometimes it comes up. Here's what I think really happened in that. Earlier in the trial, about an hour earlier, give or take, you heard the judge go on a 4-minute speech about how he does it during the opening statement. He doesn't want any of the attorneys to touch any of the things in the court because they've all been placed in a very specific location. And because they've all been placed there, if you touch it, you may screw something up. And he really made great efforts to explain this in spite of all the other things going on in court. I think part of the reason they made the Sixth Amendment was to let the jury know, sometimes you do this, to let the jury know, I got to move what I need to move. And if I want to move it, I'm going to move it. I really think that's a deep part of it. Although to be very clear, you have absolutely, as defendant, have a right to see the people accusing, the witnesses, as well as every member of the jury. And it's important we respect that and protect that in this trial. Because if we don't protect that in this trial, then you cannot protect it in other trials of people without such eyes on the case, without such publicity, without that kind of news. Number two, the second thing I want to talk about is you saw the third defense attorney reserve his opening. Now, this is very interesting the way they did their opening statements. The first attorney seemed to talk in a very professorial manner with a non-Southern accent, so to speak, manner about all the actions that led up to the actual killing in this case, and then only spoke about the killing for maybe 2-3 minutes. He didn't speak very much. The second attorney who then went, he seemed to speak more in depth in a sort of Southern colloquial accent, drawl, however you want to phrase it, manner about the actual moments of the death of Mr. Ahmaud Arbery, the killing of Ahmaud Arbery. The third attorney then, and this seemed to take the court and both the prosecutor by surprise, reserved opening. Now, you don't see that very rarely. I think I've done it 2, maybe 3 times in my career. What he decided is he's not going to give. Now, he didn't waive his opening. Waiving opening means you're just not going to give one. He reserved. So once the prosecution ends finishing putting on their case in chief, then the defense has to put on their case in chief. Well, he now has a right to give an introductory speech before the defense starts their case in chief. A very interesting strategy. Very clearly what happened is they knew the other 2 defense attorneys had spoken enough about the issue. What's he going to do? Give a third introduction? Because the prosecutor chose to prosecute 3 at the same time, and because these cases were conjoined for trial, what's going to end up happening is he's going to get, or the defense team is going to get a second chance to again lay out an introductory statement of what you'll hear in the defense case if the defense chooses to put on a case. Now, and they will. In this case, they will. Now, opening statements are not designed to be argument. You'll see they'll get very close, often stepping over the line and giving argument, but they're not meant to be argument. So he's not allowed to argue when you reserve an opening. You're not allowed to make an argument based on the prosecutor's case in chief. We'll see how close he hews to that rule. That being said, he is allowed to introduce the evidence that will come out in the defense case. That may be very beneficial for them and very hurtful for the prosecution. We'll see what happens as it comes. I appreciate you guys listening to what I think is important in this case. I appreciate you listening to me. In this, we speak about it every day. I want to give special thanks to Clubhouse, as well as the Coco Connection, one of the clubs on Clubhouse, which allows me to listen in through their room and contribute where I can. And all the things I say here are based on questions I've been asked in that Coco Connection room. So if you're on Clubhouse, look for me. You can find me there. My name is @lawyer. Thank you very much for listening to this, and I appreciate you considering my words.